Dear friends, we are now going with this video discusses about review petition strategies, tips for arguing successfully when you file a review petition, how best you can convince the court. What are the precedents? What is the jurisprudence we are going to discuss? Now, you all know this, we are talking about the writ petition is filed before a writ court, the constitutional court, under Article 226 of our Constitution, let us say. So you guys seek a writ of mandamus, writ of certiorarified mandamus or certiorari, quo warranto, all that. Writs or any other direction in the form of writ. That is how you will place yourself. The basic issue is you seek a mandamus and then you in support of your case, whether it is maintainable. Mandamus is maintainable, for which what are the conditions have to be satisfied. So you are seeking directions against a statutory body. You are seeking directions against a statutory body or a government, Union of India, or a statutory body subject to Article 12 of our Constitution that is coming under that. So that they should have duty and obligation to redress your grievance. And you are claiming a fundamental right or a statutory right has been violated. That is the criteria. So you have to be very clear when you are seeking the writ of mandamus. A direction to an executive, that is how. Now, when you are, that is under, you file the case and then the case gets dismissed, disposed. Judgment is delivered. What happens is the courts can just go through and pass an order. The open court itself, they can dictate. That is called as order. Another is they will reserve for orders and then pass a judgment based on the facts submitted by you, the other side, arguments, evidence, everything, they will give. Fine, first part is clear. So this is if it is a Supreme Court under Article 137 of our Constitution, he is empowered. And if you come to the writ court, then you can see the writ court has got the power under Order 7, that is Order XL 7 Rule 1, read with Section 114 of CPC. So, this is a statutory power. This is a statutory power. Means the statute, the parliament, confers that power to the High Court or Supreme Court, that you can review. You have the power to review the order passed by yourself. Statutory power is different from inherent power. For example, you have all the acts invariably is supposed to have inherent power, because the object of inherent power is to do complete justice. What is complete justice? When you can do review, what is the law laid down by Honorable Supreme Court? These things we are going to discuss. So, a statutory power is the power conferred to the High Court under this Act, this CPC. And the power conferred to Supreme Court under Article 137 or 145, where the Supreme Court itself can make rules and all. That is the point. Okay. So if the judgment is delivered, order is passed, you are not happy. So then you should go for appeal. So if it's High Court, single judge means division bench is there. And division bench order can be challenged before Honorable Supreme Court by way of SLP, special leave petition. So you have got hierarchical. But sometimes what happens is that's there. Everybody has got it. Even in Supreme Court, you can review. And in another situations like some special acts, like insolvency, NCLT matters, they come directly to the division bench. And DRT matters comes to DRAT decision will come to and division bench. But the problem is when you are challenging through these cases which come first itself, public interest litigations comes before the first bench or the division benches. Then it gets dismissed into next level is only SLP. That is the point. Now, what is the chance of you winning the case? Review. This is the first question, because as a lawyer, you have to make out a strategist. What is the chance that your review will be going through? Or is it an effort? That means you have to prepare the writ petition like any other SLP, and you have to pay some money, and clerkage will be there, and knowing fully well that 99.99% it will be dismissed. In Supreme Court means by circulation they will dismiss. Even though it is a statutory power conferred to you under Article 137, invariably it will go through a chamber. But you can file for an open court hearing. That also is there, but it's a discretion. And the court will dismiss. This is the case. And High Court means a reasoned order they will pass. In a writ court, they will pass a reasoned order. That is the first step. So, review, that is, you are going before the same bench which has passed the judgment order saying that you please review my case. The judgment delivered by you is factually erroneous, error apparent on the face of the record. You have to convince the court. And the court will decide discretion. Statutory right only. But they can exercise, mostly they'll dismiss. No, there's nothing to these things, you can go. Like that they will talk. Then the next question we are coming, why you want to come for review? Is it advisable? If you ask any lawyer, he'll say, no, don't go for review. It's a waste of time, one. Two, the judge himself will not agree. He may know he has done mistake, but he would not like to accept, like human beings. And the judges sitting on it's a powerful constitutional court. The judges are extremely powerful. Nothing will happen. It is a conscience-driven means, then they will immediately think, oh, we have done mistake. We have to correct it. We are not saying it is like that. Judge may think it is not required. So we will not say, you see, a person is aggrieved, always blame somebody. And it is the judge who has decided, and there is a next level is there for you. Why are you bothered about it? Right? When you go to the court, it is not necessary that you should always win, and even win or lose doesn't matter at level 1 till the matter goes to Supreme Court. You have to be clear. Right. Now, the next issue is strategy. I will come. But then how will you argue? Here one more point we are going to take detailedly about the recall power. Recall. What is the concept of recall? Now the law is well laid down. The 5-member bench judgment of Honorable NCLAT, approved by Honorable Supreme Court, clearly lays down the law. So I will take like this. Before we go into the grounds for review, Supreme Court settled Justice Bella Trivedi bench laid down a clear-cut law latest recently in a state tax department's case. When can you apply a review? Under what circumstances review can be allowed? And then the judgment came in 23 with regard to M.R. Shah, Justice M.R. Shah bench, based on Perry Kannan and then Shanti Conductors Private Limited. This is SCC 2019-20, 2019 bracket 20, SCC 763. Then the next one, that is Perry case. Then Shanti Conductor Private Limited case 2020 to SCC 677. Based on which the judgment was delivered by the Honorable Supreme Court, M.R. Shah judgment, Murali Sundaram versus J. Jyoti. That case, civil appeal 1167 of 23. These are all the things we are going to take up for discussion in this short video. I would like to say this, friends. When you are testing, there are law provides you all the avenues. Then exhaust them. But the point is, and the Supreme Court, you have to file. Suppose division bench dismisses, Supreme Court, you have to file the case. So what you should do is you should file in Supreme Court SLP against this order, and 5,030 rupees only you have to pay. And it will be in defectives. Definitely some defectives will be coming. We are making one more video where how to get the SLP numbered. Live case studies. I'm going to take live case studies. This is also a live case study. But introductory part we are saying. Then you come to the review. Advantage of review is they will pass a reasoned order. Mostly. Some judges may not care. But generally they are duty bound to pass a reasoned order. For example, the Honorable First Division Bench of Honorable Madras High Court, Chief Justice Gangapurwala, excellent judge, he dismissed one petition. So I filed. Then I explained to him, Lordships, you have relied upon this. You see the judgment. You see, you relied upon this judgment and dismissed. But the judgment that you relied upon is a per incurium judgment, because in that judgment against that was my order only, I raised the issue of equality. You are treating equals as less than equals. So that is my issue. But the judgment delivered is based on a Sampath Ganesh versus Union of India, which talks about multiple regulators. There is no connection. Lordships have decided this judgment based on that judgment. In fact, the division bench of Honorable Mumbai bench also taken that same stand based on my judgment delivered by Honorable Madras High Court. So, in other words, the first judgment in writ petition 13-229 filed by me of 20 was the basis for Mumbai division bench to dismiss another petition filed by somebody. Secondly, it is the basis for dismissing the other writ petition 16-650. But that judgment is inherently flawed. It's a per incurium non-est judgment delivered by other division bench of Madras High Court, Justice Sahi, AP Sahi bench. So the judges are so good, they heard. But they said, when will you apply review? When we have not considered something which you have pleaded. But here, we have considered what you have pleaded, and we relied upon a coordinated bench. Two things. When you have considered the issue raised by you, 1 + 1, you are saying 2. The court says 3. That means they have considered 1 + 1 is 3. That's all. Whether it is wrong, 1 + 1 is 2 and not 3, go to next level appeal. That is the review means. Suppose I am saying 1 + 1 is 2, the judges did not consider it, then review applies. That's all, friends. Simple. That is how you should consider the review. Nothing else. So beautifully, Gangapurwala justice, wonderful, amazing. In fact, he told me when you argue constitutional, it's like a music to us. as a great encomium to me. He was such a good judge. Any other judge would have dismissed just like that. Who is this fellow to come? He passed a reasoned order. Justice Bharata Chakravarti only passed order. They are very kind. They are able to accept their own mistakes or errors apparent on the face of the record. It is not an error apparent on the face of the record. That is what he explained. Honorable Justice Kangar Kapoor, he did not think that is the law. One word you can want to understand, review. This is review. Review cannot be, you cannot file review in the disguise of a reappeal. Court also has no jurisdiction to allow it. In other words, a matter is pleaded by you and it is considered. Whether it is right or wrong, that is next appeal court will decide. Even that court has no jurisdiction to consider. That is the law. Understood, friends? You can take Bala Trivedi madam's case, and she has lordships have passed the judgment. If you see that judgment, the scope of review, this is how it was written in the judgment. After taking note of various decisions, the court stated that following: a judgment is open to review inter alia if there is a mistake, underline mistake, or error apparent on the face of the record. A judgment pronounced by the court is final, and departure from that principle is justified only when circumstances of substantial and compelling character make it necessary to do so. An error which is not self-evident and has to be dictated by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise its review power. But friends, remember, you cannot go as a right and tell them you have done mistake, please accept. That they will not accept. That is there. If you say 1 + 1 is 2, so lots, you have made it 3. That's a mistake apparent on the face of the record. But they may not agree for that. You go to Supreme Court and say. Therefore, the best thing, whether you pleaded this matter, was it considered or not? Considered and wrongly passed order, no problem, it's gone. It's a mistake. Mistake also they will not allow. Though it can be allowed. If it's a fair judge, he may allow. But they won't allow. Then that is, you are going to tell them that this is not at all considered. This is what I said. It was not at all considered in the order. Therefore, the court has to review. That's all. Okay, friends. Now I'll take the next video. I'll take a live case study. How it was argued. And we have video recordings. And once the case is over, we can, this is because students have to learn how the judges are looking at it, how you have argued the case, and what you could have argued better, what judges have missed out, what is the alternative remedies, how it can happen. All these things we are going to take up for discussion.